morning. Welcome to the program Law and Order. The Law and Order program where we discuss the current issues and legal solutions for your legal questions we provide within this program. And today we are going to discuss an extension about the law of property that we discussed earlier in our previous episode. And to do the honors today as well, we have with us Mr. Ian Fernando, Senior Counsel and Attorney at Law. Thank you very much for accepting our invitation and joining our program today as well. So when it comes to the law of property, it is a diverse field which cannot be confined even to one episode of discussion. So today also we are going to enlighten certain areas on property with numerous case laws, and when it comes to court practice, certain interesting areas that you would convince to have it in a discussion. So sir, we'll just elaborate a little bit on law of property because it's a diverse field and the areas pertaining to that.
Yeah, law of property is very diversified. You get different types. You get the conveyancing law regarding the transfer and mortgaging and gifting of properties. Then you have the legal cases where we have possessory action to repossess the land that you have given. We have rent and ejectment cases. We have to eject the tenant and get back the premises. Then we have other matters like Paulinian action where judgment has been given, and whilst the judgment is given or during the pendency of the judgment being given, you transfer the property to a third party. And you get the normal re vindicatio action where you are entitled to vindicate your title against someone else, wherein you say that you are the owner of the land and that person has no right, title and interest to stay on the land, is a trespasser or licensee, and you ask for ejectment. So there are different types involved in the law of property.
Right. So is that included with the terms movable and immovable?
The word movable and immovable can be distinguished this way. Any object that can be moved can be termed as movable. Any object that cannot be moved can be termed as immovable. So the immovable property will necessarily be the land and building because those cannot be moved, whereas movable property will be your assets such as your motor vehicle, maybe your sports car, or maybe your bank account, or your jewelry, or your amount of wristlets that you wear. Those all come into the category of movable one.
Movable property. So something, so if it is movable in the sense, but it is permanently fixed, is that a movable property or an immovable?
A movable property that is permanently fixed. For an example, what would you say, Charita?
For an example, a partition that separates to a wide area.
So that you can construe it this way. It is fixed to the land and building, and it's a fixture. So fixture, if it can be removed, it becomes movable.
Once it is removed.
Yes. Once it is removable. For example, if you do a partitioning that cannot be removed, that comes into the immovable property because it adorns to the value of the immovable property. However, you can construe it to be movable if you can remove the partitioning.
Right. So in that sense, if a fixture is being removed but it causes harm to this original construction, if I am buying the property, can I claim that?
You can claim a reduction, but actually, Charita, it comes into question where you are renting out the premises and you fix air conditioners and you drill the building and you make certain ventilation holes and you change the structure of the building without the knowledge of the owner, then he can say that what you have done has made the premises deteriorate. And therefore, that can be a grounds for ejectment under our rent law and under our normal law, saying that you have transformed the structure of the premises that he rented out to you into a different formation. Without getting his opinions. Wherein in the Rent Act there was a particular case, we call it the Latin bucket toilet case, Latin bucket case as its shortened form, wherein there was a bucket system toilet which existed, but he removed that toilet and fixed a better toilet. Courts held that that is an improvement to the premises. So in those circumstances, it was not called a deterioration. Where he had done something which is an improvement, which did not construed for the grounds of ejectment under section 22 of the Rent Act, that you have made the premises deteriorate. It was only on the other hand where you had done something better to the premises, and therefore it failed on that grounds for ejectment.
Ejectment. And we have to discuss about rent and lease also, and before coming to that area we can just briefly elaborate certain terminologies and certain things that most of our viewers might have. So what is tangible property and intangible property?
Tangible property is something that property that you can feel. Intangible property that you can't feel. For examples, if it's an intangible property, maybe your copyrights. That's an intangible property. You can't feel that.
Right.
But if it's a book in your library, it's a tangible property because you can take the book into your hand.
So there's a famous case that stealing electricity, stolen things cannot be intangible, it should be tangible. So can you just explain that?
Yes, in the case of the Electricity Act, if you are found to be tapping electricity, you are in a great situation because you are moving to rob public property. So that electricity is not a tangible item. That is what you are trying to say.
Yes.
It's an intangible item. But however, that item being supplied to you, and if you have robbed it as against the public interest and it is a state funded property, you are taken into custody straight away for having tapping electricity.
Right.
And you will not be coming out of custody until you have paid the assessed amount that the electricity board has assessed amount how much you had tapped. So that can be arbitrary assessment, but they do a fairly good calculation on that. Until that sum is paid to court, you can't get your bail.
Right.
Thereafter only you can get your bail and fight the case that you have not tapped the electricity. So the Electricity Act and the officers concerning that department are well aware of that, and they will catch anyone who is caught tapping electricity and ask them to pay the balance, though it's an intangible asset, to come in to get your bail.
Right. So one of the interesting cases that we come across when discussing about tangibles and intangibles, and the way that I need to emphasize is that I need to come to public properties. What is public property?
Public property is state-owned property. So for example, even if you meet with the accident and your car crashes into a lamp post, you are supposed to pay for the lamp post to get whatever bail you want, and to come into some redress and settlement, you have to put the property back into a particular. And if you have stolen public property, that will be a grave offence because it's not a bailable offence, unless you are able to show that this is not public property. So that is where public property comes in. State-owned property is called public property. Any other property other than that will be naturally be private property.
So if it is a lost or an abandoned property, will it be a public property because no owners are there?
If it is a lost and abandoned property, there would have been an owner at one point of time, but if the government has taken it over by a gazette, only it will become a public property.
So
otherwise the Roman Dutch law principle of res nullius, no one is the owner of that, is basically what you could construe it to be. But res nullius will not apply if the government has gone in and they have gazetted it and taken over the land. For examples, you get so many roadway cases where parties are fighting on a roadway, on the servitude right of the roadway and the user right basically with the ownership. What the municipality does is, if they are made a party, they come in and pass a gazette and acquire the land under the Land Acquisition Act and make it a public roadway. So the whole thing is sorted out.
Right.
The whole issue of going to court and sorting out your rights on that roadway is sorted out by the government acquiring that land under the Land Acquisition Act or whatever necessary acts and making it a public roadway.
So coming to the flow that I emphasized on my discussion, basically I do have an immovable property which is a land which is close to my land. It is not a public property, so nothing interferes with the state, but yet no owner is there, is an abandoned property. But I feel like putting up some crops there at my adjacent because no owner is there. Is it legal?
You can put up the your produce and see whether anyone comes to use up your right. Otherwise, you can merely go on and if you can show, even if you are not in physical possession of the land, so many estate owners are not on physical possession, but they own the land, and if you can show that over 10 years you have been cultivating this land, and that you have been fencing this land and nurturing this land, possibly you can write a deed of declaration that you are the owner of the land.
Claiming the prescription right.
Claiming the prescriptive title.
Right. So can we do anything? Put up a building?
Yes, you can put up a building, but then there might be at that point of time some neighbor who will come forward to say that he also has rights, but otherwise if you have uninterrupted possession for 10 years after putting up a concrete structure, you might get through with the deed of declaration, but you will have some difficulty at the municipality in trying to put up on a premises of getting the building approval, which is called the certificate of conformity subsequently after you get the building approval, when you are not the owner of the land. So you will have to consider whether what type of deed you are going to have, the deed of declaration to get for the certificate of ownership. That you can prove the municipality, and to get your building permit also to build on the land will be an issue with the buildings department of the municipality, whether you can build on a land where you are not the owner. Those are the legal snags there.
So suppose that I do have a property, I'm living abroad. When I come here after 10 years, someone have put up a building or crops or whatever in my building. So he is claiming that he has used this land for 10 years and he is claiming that prescriptive right. So what can I do as a real owner?
The prescription ordinance sets out very clear procedure that if you are living overseas, I forget the section is, I think the one or two sections before the last section, which talks about the crown property of the last section, it says that if you are living overseas, prescription will not run. So from the time you have come into Sri Lanka and gone, if you have lived 10 years, if you have been there and he has been in Sri Lanka, then of course you can make out a case, but he will say that he was in possession of the land.
Uninterrupted possession.
For example, if he is there from 2000 to 2005 overseas, and you are there from 1995 to 2005, and he comes down in 2005 and puts up a fence or comes into his land, your prescription is broken. In 5 years time your prescription is broken. And also the fact that he is abroad, the prescription ordinance, the prescription doesn't run adversely because he is abroad. It's only if you are in Sri Lanka that the prescription will run.
It's specifically mentioned in the act. So when it comes to a vindicatory action, how does it apply to property?
Vindicatory action is generally done when you want to vindicate your title against a trespasser or a person who is overstaying a lease or a tenant or even a licensee, wherein you come to say that you are the owner of the land and you have no right, title or interest of the land. So you can be holding possession of the land on 4 grounds, as I mentioned earlier, as a licensee, as a tenant, as a trespasser, or otherwise or some stakehold owner. Those are the grounds that you can hold on to as a defense. But you have to be able to prove that defense. So court will go into the finding of your title for the at least 35 years, because 33 and 1/3 year is the required amount for prescription against another co-owner to be, and the court will decide, that is why court will take more than 35 years to decide that you are the owner of the land, and the person who is there as the defendant has absolutely no proper right, title of interest on his defense to stay in the land, and then he will be ejected. He will be ejected if your letter of demand is correct or your notice to quit is correct. He will be ejected and he will have to pay damages for his unlawful occupancy from the time you are set out in your notice to quit.
Exactly. So when it comes to a property co-owned by few people, if I want to put up a business or use that particular land, will it be an obstacle to genuinely claim my right?
You have to claim the portion of your land to put up that building, and in doing that the other co-owner should agree. Otherwise, if you go and build on a co-owned property, another co-owner can stop you from building if he doesn't like it, because he has the same amount of interest that you have on the land. So in a scenario like that, it's best to go for a partition case and get your boundaries divided and defined, and then put up your building after you have a separate assessment and a separate number and separate demarcations of your meets and bounds,
Right.
so that boundaries where you can put up your building.
Right. So that is my next point when it comes to partition actions. For an example, we have a land plot. Suppose that myself and my brother owns that co-owned property. I need to have that right side of the property. For an example, this side. My brother also need the same side. A conflict of interest.
When you go in for a partition case, the court will decide who nurtured that property and who maintained that property and who developed that property on the right hand side. If you can prove that you have done it, you will get the right hand side.
Right.
If he can prove that he has gone and built a toilet and a well on that land, on that side, then he will be entitled to that. So when co-owned property is between parties, it's very necessary to see, because all have the equal share, with who is going to put up the building and where, and whether the others are objecting. If the others are objecting, then you have to go to court and get your property defined. If others are not objecting, you are entitled to put up the building or whatever you want in that particular portion. And when the partition case comes up, you can demand that you be entitled to that portion of the land, which is the correct share that you have to get, because you have put up a land or you have put up a building on that particular area, which you have now spent so much money and you have been in occupation for several years.
Several years. So that is property basically when it comes to the claiming right and partnership and ownership. So when a property is clear and everything, if my own property, I want to give it for a rent or lease. So define what is rent and lease.
Rent comes into the question of month-to-month tenancy, and our Rent Act applied under certain provisions of the law, and outside the Rent Act also we rent out premises. Those premises that we rent out outside the Rent Act are called exempted premises, which the rent laws do not apply, and leases are in general that you lease property for a certain period of time.
Right.
Now in the Rent Act also you get leases. In the Rent Act, the lease says, I think at section 29, if I was right, for a period of 5 years.
Right.
That is the stipulated amount given. And you can state that on a happening of an event that you want the premises back. For example, your son becoming a lawyer, or your daughter joining medical college,
Right.
or your eldest daughter getting married, can be specified in that act, in that lease agreement. And therefore, you can, on between that second year and fifth year that happening of an event takes place, you can move to send that person a notice and ask him to leave. So that's a very good grounds under the Rent Act. It's a loophole in the law to get your tenant to formulate into a lease and have a happening of an event to eject him in a situation where you find it difficult to eject him, because the rent laws are so stringent. When the rent is standard rent is under 100 or sometimes over 100, you have a difficulty in ejecting your tenant. So this is a loophole in the law where you can ask for a lease agreement to be signed between parties embodying the Rent Law, Rent Act 7 of 1972 and its amendments, and put this happening of an event clause under section 29 or 36 of the Rent Act, I am not quite sure, of the lease, and then move to eject him in 2.5 years' time, saying that your son became a lawyer now and you need the premises. He has absolutely no defense.
No defense at all. Right. So when it comes to rent, if I have mortgaged my property to a bank and obtain a bank loan to put up the building, so now I'm going to rent the premises. Is it okay?
Yes, you can mortgage the premises and you can on that mortgage pay the rent, the rental of the bank, that is your loan repayment from the rent that you received. I don't want to mention names, but I know a top businessman who has taken a loan from a particular state bank. I don't want to mention the bank also. And he pays less than the interest that he should pay back to the bank on the loan, but he gets much more than that on his renting out of the premises. That's what you call a very successful businessman. Also, you get people who will sell their land or rent their premises in the city areas and move to the urban areas out of Colombo and pay lesser rent and still have a huge margin to be deposited in the bank where they can survive on. That's very good very good
thinking and business tactics. So when it comes to state lands, huge time period, 99 years agreements, what sort of agreements are they?
State lands are different types of agreements. The leases are given for 33 years, 66 and 2/3 year, 33 years and 1/3 year, 66 and 2/3 year, and 99 years. In those leases, they set out the land must be developed. It's called the Land Development Ordinance. According to the Land Development Ordinance, say if it's given to particular person called A, the father of the family, and he dies, then the Land Development Ordinance sets out the procedure in which the inheritance comes in. It comes in next to the child, who is the son, who can develop the land. So that's purely given for the development of the land. You may see in places like Mandaravel and the outskirts of Colombo, where land has been given, maybe 10-15 acres, for you to develop and live on the land. That doesn't mean that you own the land. You can put up a building, but at one point of time, government will ask the premises back. But what we see in today's context is, when you have developed the land and put up a building, the government of Sri Lanka will try to see how you can have the land for your future. So if the father has died and the son has inherited the land, they will see that the son gets the land under those schemes that they have, Swarna Bhumi and Jaya Bhumi schemes
as well. Right. So when it comes to moving back to the topic that we were discussing, so when it comes to a rented property, if I'm on rent, can I put up a building there in that property?
If you're on rent, you certainly can't put up any building on the property.
Neither can't
you
demolish.
Can't do any extension on the property. You cannot demolish. If you demolish under the Rent Act under section 22, that will be another grounds for you for being asked to leave the premises. Ejectment notice served on you that you are trying to demolish the premises. But however, under the Rent Act, if the premises is over 50 years old, you are entitled to ask the landlord to rebuild the premises into a habitable state. And you can go to a rent board and make an application that you be able to get a habitable place. So until that habitable place is built, you will have to be provided with alternative accommodation by the landlord until he builds that premises for you, maybe 6 months, agreement signed, and once the premises is built, you are entitled to come back into the said premises.
So when it comes to rent, we must have a proper agreement. Under that agreement, can we sublet that? Subletting is allowed or not? What is the legal background?
The rent law happens this way. According to our Prevention of Frauds Ordinance, section 2, every transaction regarding land and building has to be notarially executed. That means a lawyer who is a notary, or a notary basically, should sign with 2 witnesses with the parties concerned at the same time. So once you have given a lease or you are in occupation, you cannot do a sublease. You cannot rent the premises to someone else unless you have got specific provision in your lease agreement or your rent agreement that you are allowed to sublease. Subleasing is also a grounds under the Rent Act under section 22 for the grounds of ejectment if you have sublet the premises.
So that we discuss certain grounds of ejectments also, and we come into the latter part of this discussion. When we obtain rent, what is the most convenient and most transparent way? Is it bank transfers or having cash?
Having cash and getting a rent receipt is a good grounds, because in our law it has been construed under particular case law that if you have one rent receipt is sufficient to prove that you have a tenancy between the landlord and the tenant. But the easiest thing would be to send a bank transfer and get him to give you a receipt. And Charita, I must say, in context like today where we are having COVID and so many other issues in this country, the recent lease agreements I have seen certain clauses coming in like force majeure, act of God, and now even COVID-19, that the person who is receiving the lease, possibly a business lease, he will put a clause to the lessor to say that in the event of some unfortunate happening like COVID-19 takes place again, that the rent will be reduced by 50%. So those agreements who have clauses of that nature for situations that are arising at this moment, they are benefited by not being able to give the required rent due to the economic conditions and the business temperament of the country at that particular time. Particularly if you have put a clause like that only in the agreement.
Only in the agreement.
I know very shrewd businessmen who have put those clauses and who have recouped so many amounts of profit, or I would say not done any expenses due to the fact that they have got themselves covered. That in the case of something like COVID-19, the rent will be slashed down by 50%.
50%. But for that purpose, we have to enter the clauses in the agreement.
You have to be very mindful of the fact and enter those clauses.
That should be in a precise manner, the agreement.
Precise manner.
Right. Okay. So thank you very much, sir, for enlightening us on all those matters with regard to property. And the latter part of the program, we were able to discuss rents, leases and subletting and so on, which might be very important for you all in dealing with the current context as well. So Law and Order program, as you basically know, we provide you the solutions for your problems, and stay tuned with many more episodes which will facilitate you to obtain the solutions for your own problems. And we are going to move with another episode in the next week as well. Stay tuned until then. So thank you very much, sir, Mr. Ian Fernando, attorney at law and senior counsel, for taking part in this program. Thank you very much, sir, and thank you very much, ladies and gentlemen, for watching us on this Law and Order program. Thank you very much, and have a pleasant day until we meet again.